didn't have a chemistry read as Ryle and Lily. We had, the very first time we met, we had a 3-hour meeting, and by the end, I just knew she was Lily. But no, we didn't have a chemistry read. We did have chemistry reads with Lily and Atlas's, with Ryle and Lily, and so, I'm grateful and hopeful that there's chemistry on screen. So sometimes, during this process, as I'm playing Ryle or as I'm directing, there's just...
All right, friends, today we need to talk about something that is honestly messy, complicated, and kind of shocking. Blake Lively has jumped into the courtroom again, and from the way things are unfolding, it looks like she might have really jumped a gun and ended up embarrassing herself in the process. Now, I know that sounds dramatic, but trust me, by the end of this breakdown, you will see why people are calling her legal move premature, desperate, and even reckless. So what exactly happened here, Blake? Filed a motion where she basically demanded the court give her attorney fees, punitive damages, and treble damages under California Civil Code 47.1. She was telling the court that they should not wait until the entire case is resolved. She wanted a decision now, right away, no waiting, no patience, just give it to her immediately. Now, you might be wondering why that is a problem. The issue is simple and yet huge at the same time. There has not even been a decision about which state law applies to this case as a foundation. Without it, nothing else can happen. New York law, California law. They are completely different in how they handle defamation fees and damages, and the judge still is not chosen. So when Blake tells the court, hey, award me damages under California law right now, she is asking them to jump steps that have not even been established. And let me tell you, that is not how courts work. Judges do not like being told to leap ahead like that, especially when the groundwork is not set. To understand why this is a mess, you have to know what FEHA is. That stands for Fair Employment and Housing Act of California law. That has very specific rules. It does not apply everywhere, and it does not stretch outside of California, unless there's a really strong connection to California. For example, if an employee lives and works in California, then yes, FEHA applies. If they live and work in New York, then no, it does not apply. Even if the employer is a California company. In this case, Blake is not a California resident. She lives in New York. The alleged conduct did not take place in California. And while Wayfair, the company involved, is based in California, that connection alone is not strong enough under most rulings to drag California law into a New York court. Federal courts, especially outside of California, usually refuse to extend FEHA unless the events have a direct California link, and that link here is shaky at best. So when Blake tried to say, hey, this is clearly California law, looked like she was skipping the homework, like she wanted the final grade without doing the assignment. Now here is where it gets more awkward. The judge already gave hints earlier. When he dismissed part of the case, he wrote a massive 132-page dismissal order, and in it, he carefully avoided locking himself into one state law. He literally said the law applicable to Reynolds and Sloan's claims could not be determined yet. He also said he was not going to decide whether Blake's statements were privilege under California Civil Code 47.1 unless and until there was more development. That means the judge himself told everyone we are not there yet. We do not know if it is New York law or California law. And yet here comes Blake telling him, actually, judge, we do know it is California, and I deserve damages right now. Can you see how that looks embarrassing? It is like standing in class when the teacher says we are not grading the test yet, and you shout out, I got an A, give me my grade now. So let us break this down, because this is where the real tension comes in. If the court decides that New York law applies and the outcome is completely different than if California law applies under New York law, you cannot get treble damages. You cannot get special punitive damages for defamation beyond what is already allowed under common law. And the anti-SLAPP law in New York is very specific. It only gives mandatory attorney fees if the defendant wins, but under California law, section 47.1 is way broader, allows not just fees, but also treble damages and punitive damages. That is a massive difference. Blake wants California law because it gives her more money, more leverage, more of a weapon. Her opponents, Reynolds, Sloan, and the PR firm want New York law because it favors them and keeps things more narrow. The judge has to make a choice, but he has not made that choice yet. He literally said he does not need to pick because the claims failed under either state law. That is why he dismissed the case already. He said, look, whether I use New York or California, this case collapses. That means he deliberately avoided the choice of law question because he did not need to answer it. And that is why Blake's motion looks desperate. She is trying to force his hand. She is saying, I do not care that you have not picked California law yet. I am going to assume you did. And I want my damages now. That is bold, that is risky, and honestly, that is kind of reckless. Here is what the judge needs in order to even consider Blake's request. He needs to know if her statements were made without malice, because under California law, she only gets damages if she proves she did not act with malice. And how do you prove that? Either through a trial or an evidentiary hearing. The judge has said that no one has done that yet. He has not ruled on malice. He has not looked at evidence. He has not made findings. But Blake is acting like it is already decided. She is saying, trust me, I was not malicious. I was acting in good Faith, so give me my damages now. That is not how courts work. Judges do not hand out trust me awards. They need evidence. They need findings. They need to check the boxes. Blake skipped every single one of those steps. So Wayfair called her out to argue that her motion is nothing more than a recycled sanctions request. She already filed 2 sanctions motions before, and both were ignored or not ruled on. Now she filed the same thing again, just dressed up as a new motion for treble damages. It looks repetitive. It looks like a publicity stunt. It looks like she is doing it not for the court, but for the headlines. And honestly, if you follow celebrity cases, you know this happens a lot. Sometimes motions are filed less for the legal win and more for the media splash. It gives the star something to point to in interviews or press leaks it makes. Them look strong even if the motion is legally weak. Now, let us talk about the judge for a moment, because this adds another layer. This judge has already shown that he will stretch the law to clean up his docket. He used unpublished rulings in his earlier dismissal. That is unusual, because unpublished cases do not carry precedential weight. They are not binding yet. He leaned on them anyway. That makes his earlier ruling very vulnerable to appeal, but it also shows he wants this case off his desk. He does not want to drag it out. He does not want endless motions clogging up the system. So now Blake is pushing him to take a brand new leap. She is asking him to apply California law that has never been used in this way in federal court. She is asking him to decide a first impression case and give her treble damages right now. That is asking a lot from a judge who already told her he does not want to deal with this. You can almost feel the frustration from the bench. He told her before, do not bring me this again until something changes. But she brought it again. Nothing changed. She just wrapped it in new paper and called it something different. Here is where the emotion comes in. Imagine you are Blake. You feel like you were wronged. You feel like your reputation is damaged. You believe that Wayfair and the others made you look bad. And now the judge has dismissed parts of your case. And you are angry. You want justice. Fast, you want the court to say, yes, Blake, you were right. And here is money for the damage. From her perspective, this motion probably felt powerful. She was taking back control. She was saying, I will not wait. I will not be sidelined. But from the court's perspective, it just looked sloppy and rushed. It looked like she was ignoring the rules and skipping the process. And that is a hard why this whole thing feels embarrassing. It is not just about the law. It is about respect for the process. And judges hate when someone disregards the process. So let's imagine the judge finally decides that New York law applies. What does that mean for Blake? It means she basically loses her shot at treble damages and punitive damages. Those do not exist under New York defamation law. The only thing New York allows is standard damages. If you prove defamation plus the anti-slap law that says if a defendant wins, they get their attorney fees. So in that world, Reynolds, Sloan, and the PR firm actually get stronger. They can turn around and ask for their own fees. They can say, look, judge, we won under New York anti-slap. Now give us our money. Blake will be completely blocked from the California remedies she wants so badly. That is a nightmare scenario for her, and honestly a very real risk. Judges in New York federal court lean toward New York law, especially when the plaintiff lives in New York, works in New York, and says the damage happened in New York. The New York Times article at the center of this whole thing is a New York publication. Blake's reputation damage would be in New York, where she lives. That is a very strong case for applying New York law. And if that happens, Blake's motion is not just premature, it's pointless. She will have wasted time, money, and credibility. Now let us flip the script where the judge surprises everyone and says fine, California law applies. That is the dream for Blake, because then she can pursue section 47.1 damages. She could argue for treble damages. She could go after punitive damages. She could say that her harassment complaint and her claims deserve the strongest possible remedies. But even in that dream scenario, she still faces huge problems. She still has to prove she acted without malice. She still has to show evidence. She still has to go through hearings or trials. That part cannot be skipped, and she has not done any of that yet. So even if California law wins her motion, it's still early. It is still jumping ahead. She would still need to go back and fill in all the missing steps. That is why this is so baffling, even in the best case scenario. She is not ready to collect those damages. Now here is the part that really stings. The public is watching, and the media is covering every twist. When fans hear that Blake filed a motion demanding damages right away, they see someone who is impatient, entitled, and reckless. It makes her look like she is using the court as a PR tool rather than a place for justice. And that image hurts her reputation. Is not just about this lawsuit. It is about how she is seen in Hollywood and in the public. People believe she is abusing the legal system for her headlines that sticks, that follows her into future roles, partnerships, and media opportunities. On the other side, Wayfair and their attorneys come out looking steady, patient, methodical. They keep telling the judge this is premature, this is not ready, this is outside the rules. That makes them look credible even if the underlying case is messy. So while Blake thought this motion might give her the upper hand in the headlines, it could actually backfire in the court of public opinion. Let us talk about judges for a moment. Judges have overloaded dockets. They are swamped with cases. Every motion they read is hours of work. When a lawyer files something premature, the judge sees it as wasted time. They see it as someone trying to force them into a decision before the groundwork is laid, and that irritates them. In this case, the judge already made it clear he did not want to decide the choice of law, yet he already said he was not going to handle fees until later. So when Blake filed this anyway, it looked disrespectful. It looked like she was ignoring his orders. Judges do not like to be ignored. That is why this could have long-term consequences. Even if Blake's legal team files something strong, later the judge may remember this premature motion and feel less sympathetic. It is like burning a bridge with the very person you need to persuade. Now, let us pause and really think about what might be going through Blake's mind. Imagine the stress. The headlines are constant speculation. She probably feels like she is fighting not just in court, but in the media every single day. Maybe she wants to send a signal that she is still fighting, that she is not giving up. Maybe she thought this motion would scare Wayfair or pressure them to settle. Maybe she thought fans would see it as strength, but instead it comes across as impatience. The law is slow. It takes months, sometimes years, and that is exhausting for anyone, let alone a celebrity who is used to controlling the narrative. Maybe in her frustration, she told her lawyers to push hard and file whatever it takes. Maybe this motion is a result of that emotional pressure. If that is true, then it makes sense emotionally, but legally it is still weak. It shows why emotion and law do not always mix. Well, this is not just about one lawsuit. It fits a bigger Hollywood pattern. Celebrities often try to use lawsuits to protect their image, but sometimes those lawsuits become bigger scandals, and the original problem, filing aggressive motions, can create headlines, but those headlines do not always say what the celebrity wants. Instead of Blake looking like a fighter, she risks looking like someone who misuses the system. And Hollywood pays attention. Studios, PR firms, brands, they all watch how stars handle controversy. If they see someone constantly in messy lawsuits, filing reckless motions, it makes them cautious. They worry about drama bleeding into business. That is why every move here matters, not just in court, but in career. So what happens? Next, the judge has several options. He can deny Blake's motion outright, saying it is premature. He can delay it until the choice of law is decided. He could even scold her team for filing too soon. That would be embarrassing, but it would not surprise anyone. He could also decide the choice of law question finally, but that seems unlikely because he avoided it before. And if he does decide it, most signs point to New York, not California. That would slam the door on Blake's motion entirely. The wild card is appeal. Wayfair could appeal parts of the dismissal because the judge relied on unpublished rulings. Appeals could bring new scrutiny to the entire case, but appeals are slow and unpredictable, so that is a long road ahead. For now, the most likely outcome is nothing changes. The judge will probably push this off until later or deny it altogether. Blake will have spent resources and credibility for nothing, and that is why people are calling this embarrassing. Blake Lively wanted to look strong. She wanted to force a win, but instead she skipped the steps and told the judge to hand her a victory that was not even ready. That is not power, that is impatience. And in the courtroom, impatience never wins. So what do you think? Was Blake being bold or reckless? Was this a smart attempt to control the narrative or a huge mistake? Let me know in the comments below. And if you want more breakdowns like this, make sure you subscribe to Star Celebrities and turn on notifications, because we dive into all the twists and turns of celebrity legal battles. You do not want to miss the next